Today, we'll explore the complexities of race-conscious and race-neutral policies in K-12 and higher education settings. Between admitting students and hiring staff, the decision-making process is fraught with potential legal landmines. The U.S. Supreme Court's decision on students for the Harvard has a significant impact on race-conscious policies in admissions. And as if that were not challenging enough, new legislation around the hot-button issues of divisive concepts adds yet another layer of complexity. As of 2023, legislation has been proposed and signed into law in many states to limit the teaching of concepts such as racial scapegoating and racial stereotyping. To lay the legal foundation, let's start with Equal Protection Clause of the 14th Amendment. This constitutional amendment serves not only as a legal cornerstone for challenging race-conscious policies, but also as an important instrument aimed at rectifying the long history of racial discrimination against Black Americans, among others. The amendment states in part, no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within jurisdiction the equal protection of the laws. Building on this constitutional foundation is Title VII of the Civil Rights Act of 1964, a landmark legislation emerged from the American Civil Rights Movement. This act specifically targets employment discrimination and was instrumental in dismantling systemic barriers that had long disenfranchised Black Americans in the workplace. Title VII stipulates it shall be an unlawful employment practice for any employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin. With the legal frameworks in place, we are now positioned to explore the complexities of race-conscious policies, examining how they align or conflict with established laws. Now, what exactly are race-conscious policies? They are policies that explicitly take race or ethnicity into account during the decision-making process. One of the most recognizable race-conscious policies is affirmative action in the context of college admissions. University of Michigan aimed to create a divisive educational environment by taking race into account as one of many factors during the admission process. This approach led to the famous Supreme Court case Grutter v. Bollinger in 2003. Barbara Grutter, a white applicant, challenged the university's policy, arguing that she was rejected in favor of less qualified minority applicants. The Supreme Court upheld the university's policy by a vote of 5-4, arguing that educational diversity is a compelling state interest. However, the Supreme Court decision stipulated that race could be a factor, but not the only factor, and that such policies must be regularly reviewed for efficacy. Another example of race-conscious policy is Pfizer's Breakthrough Fellowship Program, which offers college juniors a pathway to employment at Pfizer through multiple internships and fully funded graduate education. The program's eligibility criteria explicitly aim to increase the representation of Black or African American, Latino or Hispanic, and Native American individuals, thereby restricting application to those racial groups. In the K-12 education context, unlike regular public schools, magnet schools often have specialized curriculums and can be selective in their admission processes. To mitigate the effects of residential racial segregation on school composition, Some magnet schools use race-conscious criteria as part of their admissions lottery or point system. For example, a certain percentage of seats may be reserved for students from underrepresented racial groups. A point system could give additional points to students from these groups. While this approach may counteract the effects of residential racial segregation and enhance racial and ethnic diversity, it can also be a source of contention among parents and stakeholders who argue for purely merit-based admissions criteria. Race-neutral policies are those that don't explicitly consider race, but could have the effect of diversifying school or institution. Texas enacted a policy that admits students in the top 10% of their high school graduating class to any of the state's public universities, including the flagship University of Texas at Austin. The intent behind this race-neutral policy is to increase college access for all high-performing students, irrespective of racial or ethnic backgrounds. Because of historical and ongoing residential segregation, schools themselves often have racial imbalances. Therefore, a top 10% rule can indirectly lead to a more racially diverse student body. However, critics argue that it may not adequately address the complexities of the educational inequality. The rigor of the curriculum can vary widely from one school to another. Students from schools with advanced curricula may find themselves at a disadvantage if they narrowly miss the top 10%, but have completed more advanced coursework than those in the top 10% at other schools. Critics also argue that the policy could dilute the concept of meritocracy by providing an overly simplistic metric, that is, class rank, that fails to capture the nuanced nature of students' ability and achievement. Moreover, even though the policy is race-neutral, it may not sufficiently address the representation of all minority groups, especially those that are underrepresented even within racially diverse settings. Another example of race-neutral policy is blind resume screening. In this approach, identifiable information such as names, gender, and racial or ethnic indicators are removed from resumes and applications during the initial screening process. This allows hiring committees to evaluate candidates based solely on their skills, experience, and qualifications, thereby minimizing potential biases. In the education sector, this could be particularly beneficial for reducing bias against candidates from underrepresented racial and ethnic groups or of a particular gender. It focuses the initial evaluation on competencies, past performance, and potential fit for the role without the influence of demographic factors. Race-neutral policies are generally less likely to be legally challenged, but can still run afoul of the law if they result in disparate impacts on different racial groups. For example, a merit-based scholarship could unintentionally benefit one racial group over another, leading to potential legal challenges. Institutions may have to prove that the policy is necessary and not just a pretext for discrimination. When it comes to hiring and promotions in the education sector, qualifications should remain a central factor in hiring and promotions. When we speak of qualifications, we are referring to the essential and preferred skills, experiences, and educational background that a candidate must have for a specific role. Prioritizing qualifications ensures that the most capable individual is placed in the role, benefiting not just the institution, but also the educational outcomes of students. For example, in K-12 settings, administrators may need to have both teaching experience and a master's degree in educational leadership to effectively understand both pedagogical and managerial aspects. In higher education, a dean may be required to have a PhD along a track record of academic publications and administrative experience. While race becomes a significant factor in hiring and promotion decisions, the risk of legal challenges increases substantially. This is not merely an abstract notion. It's codified in the U.S. law under Title VII of the Civil Rights Act of 1964. According to this act, employers, including educational administrators, are prohibited from making employment decisions based on race, color, religion, sex, or national origin. The case of Ricci v. DeStefano 2009 serves as an important example for administrators in educational settings to understand the nuanced implications of race-conscious decisions in hiring and promotions. In this case, the city of New Haven, Connecticut, invalidated the results of a promotional examination for firefighters after it found that the test was disproportionately favoring white candidates over minority candidates. The city's justification was that if they proceeded with the promotion based on the test results, they may face a lawsuit for racial discrimination under Title VII of the Civil Rights Act. However, white firefighters who had scored well on the exam filed their own lawsuit claiming that they were discriminated against based on their race when the exam results were invalidated. The U.S. Supreme Court ruled in favor of the firefighters, stating that New Haven's actions violated Title VII. The court held that before an employer can engage in intentional discrimination for the asserted purpose of avoiding or remedying unintentional disparate impact discrimination, the employer must have a strong basis in evidence to believe it will be subjected to disparate impact liability if it fails to take the race-conscious discriminatory action. Just like the promotional exam in Ricci, any test or evaluations used in hiring or promoting staff must be rigorously designed to avoid racial biases and should undergo periodic reviews. If an institution believes that a race-conscious policy is necessary, there must be strong documented evidence to show that the policy is intended to remedy a clear historical racial imbalance. In U.S. constitutional law, three main levels of judicial scrutiny are applied when evaluating the constitutionality of a governmental action: rational basis, intermediate scrutiny, and strict scrutiny. Rational basis review is the least rigorous form of judicial review. To pass this review, a policy by the government, public schools, and higher education institution included must show that there is a legitimate interest behind the policy, and the policy is rationally related to that interest. Intermediate scrutiny applies to cases involving discrimination based on gender or sex. To pass this level of review, the government must show that the policy serves an important governmental objective and is substantially related to achieving the objective. Strict scrutiny is the most rigorous form of judicial scrutiny. It's applied to cases involving race or ethnic discrimination. The government must show that the policy serves a compelling governmental interest, it's narrowly tailored to achieve that interest, and is the least restrictive means to achieve the objective. When race-conscious hiring and promotion decisions are made in educational settings, they're subjected to the highest level of strict scrutiny. It is often difficult to pass because under strict scrutiny, the institution must prove two key points: compelling interest and narrowly tailored. You must first show a compelling interest to justify the use of race in your policy. For example, you can argue that creating a diverse educational environment is important for enhanced learning and is therefore a compelling interest. Even if a compelling interest is identified, the institution must also demonstrate the race-conscious policy is narrowly tailored to achieve that specific interest. The policy must also be the least restrictive means to achieve the intended goal. The institution must also consider whether race-neutral options could sufficiently achieve the stated objectives before implementing race-conscious policies. If race-neutral alternatives are found to be effective, then the race-conscious policy is less likely to pass strict scrutiny. Here are some examples of race-conscious policies related to hiring and promotions that could potentially trigger strict scrutiny. The first example is faculty diversity initiatives. Race-conscious policies aimed at diversifying faculty in higher education often trigger strict scrutiny, a very demanding legal standard. A faculty diversity initiative may aim to hire more faculty members from underrepresented racial or ethnic groups to enrich the educational experience for all students. This can be viewed as a compelling interest because a diverse faculty can bring a variety of perspectives into the academic environment, thereby enhancing the quality of education. However, the methods used to achieve this diversity must be narrowly tailored. This means that the institution must prove that its race-conscious hiring policies are the most effective and the least intrusive means to achieve the stated compelling interest. Moreover, the institution must demonstrate that it considered race-neutral alternatives before adopting the race-conscious policy. Race-neutral strategies could include broadening the recruitment pool to include candidates from a variety of academic backgrounds, or implementing faculty development programs aimed at attracting a diverse range of scholars. If those race-neutral strategies are found to be ineffective or insufficient, only then can an institution reasonably consider race-conscious methods. Even so, those methods must be continually reassessed to ensure they remain the most narrowly tailored means to achieve the compelling interest of diversity. The implementation of such policies must be documented meticulously. Documents will be critical should the policy be challenged legally, because the institution will have to prove that its policy withstand the strict scrutiny standard. You may need to provide documents such as minutes from meetings where the policy was discussed, including all dissenting opinions and alternatives considered. You may need to provide statistical analysis that illustrate the compelling need for diversity. This may include faculty-student ratio of different racial groups, performance metrics, or attrition rates that support the policy. You also need to document evidence that race-neutral alternatives were considered and found to be insufficient, including data analysis, trial outcomes, or expert opinions supporting this claim. Any internal or external complaints related to the hiring policy should be documented along with how the complaint was resolved. You may also need to provide a written rationale explaining why the chosen race-conscious method is the most narrowly tailored means to achieve the stated compelling interest. Another example of race-conscious policies that could potentially trigger strict scrutiny is teacher assignment in K-12 schools. In attempts to address racial imbalances in schools, district administrators may consider race when assigning teachers to specific schools. However, aiming for racial balancing as an end in itself is legally problematic and generally unconstitutional. The U.S. Supreme Court's ruling in Parents Involved in Community Schools v. Seattle School District No. 1, 2007 serves as a significant touchstone for understanding the legal limitations of racial balancing. In this case, the court determined that achieving a racially balanced student body is not in itself a compelling state interest that would pass the standard of strict scrutiny. This implies that efforts by educational administrators, when in K-12 or higher education, to create policies solely for racial balancing would likely be deemed unconstitutional. You may have heard the narrative that we have 65% of Black students, 15% of Hispanic students, therefore we need 65% of Black teachers and staff and 15% of Hispanic teachers and staff. This narrative, while aimed at promoting diversity, has been found to be constitutional problematic in the U.S. legal context. Policies that aim for racial quotas or explicit racial balancing are subject to strict scrutiny and must satisfy a compelling state interest while being narrowly tailored to achieve that interest. The Supreme Court's decision on the Seattle School District case stresses the point that any race-conscious policy, including teacher assignments, must serve a specific, articulated educational goal that can withstand strict scrutiny. In other words, the institution must be able to demonstrate not only that a compelling interest, such as educational diversity, exists, but also the policy is the most narrowly tailored way to achieve that interest. Simply aiming for racial balancing or proportional racial representation across faculties or student bodies is not sufficient. Educational administrators must exercise extraordinary caution when developing race-conscious policies. You should focus on concrete educational benefits that can be empirically supported rather than pursuing racial balancing for its own sake. You also need to consider race-neutral alternatives first. One thing I need to point out here, the legal standards for implementing race-conscious policies are more stringent for K-12 schools compared to higher education. And this is in part due to two landmark Supreme Court cases. In higher education, the Grutter v. Bollinger allowed the University of Michigan Law School to use race as one factor among many to admit a critical mass of underrepresented minority students, asserting that educational diversity is a compelling governmental interest. This gives higher education institutions some leeway in using race-conscious policies. By contrast, K-12 education was impacted by parents involved in community schools v. Seattle School District No. 1. In this case, a racial tiebreaker was a policy used by Seattle School District to allocate spots in oversubscribed schools. When more students applied to a school than there were available seats, the district used race as one of several factors to decide which students would be admitted to that particular school. Specifically, if the racial makeup of the applicants did not reflect the desired diversity targets set by the district, race could be used as a tiebreaker to tip the balance in favor of minority or majority students. The Supreme Court ruled against the school district's use of racial tiebreakers for student assignments, stating that race could not be the sole factor and emphasizing that race-neutral options must be considered and exhausted before using race-conscious strategies. The implications are significant. While higher education institutions may have more latitude in arguing that their specific context requires a nuanced approach to diversity, K-12 schools operate under greater scrutiny. They must first show that no workable race-neutral alternatives exist that can achieve the benefits of racial diversity. Only after making such a demonstration can they use race-conscious policies, which still must be narrowly tailored to pass strict scrutiny. Having discussed the stringent legal standards of strict scrutiny of race-conscious policies in educational settings, it's important to look at another legal framework that addresses how policies, even if not explicitly race-conscious, can have a disproportionate adverse effect on particular race or ethnic groups. While strict scrutiny evaluates intentional racial classifications, and disparate impact refers to policies that may be neutral on their face, but have a disproportionately negative effect on a particular racial or ethnic group. Disparate impact can occur even when there is no intention to discriminate. Under Title VII of the Civil Rights Act of 1964, policies that result in a disparate impact on the basis of race, color, religion, sex, or national origin could trigger legal consequences unless the organization can demonstrate that the policy or practice is based on a bona fide occupational qualification. It is a qualification that is absolutely necessary for the job's performance. For example, being a certified teacher may be a bona fide occupational qualification for a teaching position. The institution carries the burden of proof to show not only that there is a legitimate reason for the policy, but also there is no less discriminatory alternative that would effectively serve the same purpose. Failure to do so could make the institution liable for unlawful discrimination, even if the policy was not intentionally discriminatory. For example, a school district requires that all teacher applicants to have private pilot license, a requirement clearly not related to the responsibilities of teaching. If such an unrelated requirement disproportionately disqualifies applicants from minority backgrounds, the school district would face difficulties in demonstrating that having a private pilot's license is a bona fide occupational qualification essential for the job. This would make the policy vulnerable to legal challenges under the framework of disparate impact. I'd also like to emphasize that even if an organization has designed its race-conscious policies to be legally defensible, the way those policies are implemented could still jeopardize their legality. For example, if those responsible for executing the hiring policies use subjective or inconsistent criteria, they could create discriminatory outcomes subject to legal challenge under the disparate impact framework. It's not just the policy itself, but also its implementation that can invite legal scrutiny. A hiring committee may use criteria such as overly narrow interpretations of job qualifications or emphasis on cultural fit that disproportionately disqualify candidates from minority backgrounds. Insufficient oversight or checks and balances in organizations can exacerbate the problem. Without regular audits, training, or supervision, even well-intentioned policies can lead to outcomes that disproportionately affect particular racial or ethnic groups. Those disparities may not become apparent until an external review or legal challenges occurs, which could expose the institution to legal risk, including lawsuits and reputational damage. Today, I discussed the complexities surrounding race-conscious policies in K-12 and higher education settings. I also introduced the principles of strict scrutiny and disparate impact under U.S. law. Here are some questions that are aimed to provoke a thoughtful examination of your institution's existing policies with respect to legal frameworks discussed today. Question 1. What are the race-conscious policies currently in place at your institution? Have they been designed to withstand the strict scrutiny standard? Question 2. What compelling interest is your institution using to justify those race-conscious policies? Question 3. Have race-neutral alternatives been considered or tried before implementing race-conscious measures? Question 4. Are there any policies in your institution that, while not explicitly race-conscious, could have a disparate impact on certain racial or ethnic groups? Question 5. If such disparate impacts exist, how is your institution preparing to justify those policies? Feel free to leave your answers or comments below. Thanks for watching. I'll see you next time.